Welcome to the VAT Clinic. Today we examine the Court of Appeal's important judgment in HMRC versus Bolt Services UK Limited.
We'll look at what this means for TOMS, ride-hailing platforms, and their finance teams. The judgment was delivered on June 12, 2026, and its consequences are significant.
The central question was whether the tour operator's margin scheme, usually called TOMS, could apply to Bolt's private hire journeys. To understand the case, we must look at the shift from an agency model to a principal model. Following the Supreme Court's decision in Uber, platform contracts changed. In the agency model, the passenger contracts with the driver. In the principal model, the platform supplies the journey, making the full fare the consideration for a standard rated supply. This is where TOMS becomes critical. If it applies, VAT is paid only on the margin, not the full fare. The difference is staggering.
For Bolt, there was approximately £190 million at stake. The choice of accounting treatment wasn't just technical, it was a major financial risk.
Bolt initially succeeded at both the first tier and upper tribunals. HMRC then appealed to the Court of Appeal, challenging the broad approach taken.
The first tier and upper tribunals both focused on whether Bolt's on-demand journeys were passenger transport, and thus comparable to a travel agent's services. Both courts initially found they were.
The decision hinged on a specific legal test, whether Bolt services were identical or at least comparable to those of a travel agent. The court found that passenger transport was too general. Travel agents do not ordinarily compete in the on-demand minicab sector. This was the decisive requirement. Importantly, the court did not decide on the second ground regarding material alteration or in-house supplies. The focus remained on the scope.
The judgment strictly concerns the statutory scope of the scheme and the comparability of the services provided. We must also look at the new legislative position. From January 2, 2026, the Finance Act explicitly excludes taxi and private hire journeys from TOMS.
This statutory exclusion means the historical arguments now apply to a closed period except for transport ancillary to accommodation.
The stakes for others are even higher. Uber London Limited has already paid over £1.6 billion in VAT while their appeal proceeds.
While a recovery is not impossible, it remains a massive capital lockup. It would be premature to say Uber has definitively lost this sum. For finance leaders, this case provides a clear roadmap. We have 4 key action points to consider immediately. First, audit your historical positions. Test your comparability properly, quantify any exposure, and review your due diligence processes. The central lesson is that the Court of Appeal has reaffirmed the limits of TOMS. The comparability requirement is a high bar to meet.
Businesses must obtain advice based on their particular circumstances to navigate these complex regulations effectively. This ensures a broad thematic similarity, such as both involving transport, does not mistakenly answer that legal question.
Thank you for joining us at the VAT Clinic. If you have questions about this case, we are always here to help.